Been talking like this. I've 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 been talking like this.
Yo, we is back. Had to get up, man. I seen 4,000 people watching academics talk about a trial he don't know nothing about, so ready to get the business. Right now, this Ynw girlfriend not girlfriend, but girlfriend mother on the stand. And she ain't trying to get him nothing. Off the rip. But let's watch to see what's going on. $4,000 people watching academics. They ain't never been on trial, never had no serious court cases, or nothing. It's a goddamn shame what the world came to. Oh, god damn it. I'm gonna keep it running, y'all. Matter of fact, what I'm gonna do is I'm gonna rewind it while they in recess. Cause I ain't watched none of this shit. I knew they was ready to start recess soon. I'm gonna take it back. Now this is the first witness right here. Yeah, if y'all on Twitter, man, come to YouTube, man, so you can comment. Keep it G News.
Microphone in front of you, up or down, doesn't go back. Great. Yep. Counselor, you may proceed.
Thank you. Good morning. Good morning. Can you introduce yourself to the jury and tell them where you're currently employed?
Yes, my name is Tara Helsel, and I work at our JUVY group.
And in what capacity do you work at?
I am a forensic scientist and the manager of the forensics department.
How long have you been employed by our jury?
Since November 2016.
Can you give the jury a background into your education?
Yes, I have a Bachelor of Science degree.
Y'all know yesterday they bungled the case. The state case yesterday was horrible, so today they're going to have to redeem themselves. Yesterday, every witness that they brought on the stand was fucking terrible. But see, this the thing, y'all, that ain't nobody factoring in. This crime allegedly happened in a small town. So for them to try this, I think that's really why this murder trial took so long. You see what I mean? For this small town to try maybe a millionaire on murder, yo, that shit is damn near impossible. They don't got the resources. They don't got the resources. So a lot of these witnesses that they bringing up never even been in this type of situation. So they rookies to it. They ain't never been in this type of situation, so they don't even know what to expect, is what I'm trying to get to. And they get nervous and they sounding crazy and they fucking the case up. So that's probably one of the most important things that's going on in this trial on that favor Melly, is that this happened in a small town. Like this didn't happen in Miami. This didn't happen in Miami or one of them big cities in Florida. This was a small town, yo, that don't typically deal with these type of crimes. That's really why he gonna beat the case.
Sure.
You ain't gonna hear that nowhere else. I promise you.
Group's training program for gunshot residue analysis. And this was a several month-long process that involved reading and learning the standard operating procedures, reading relevant publications about gunshot residue. I had to complete the analysis of 250 case samples, of which my results were compared to that of a trained analyst. I had to receive training on the scanning electron microscope, which is the instrument that we use for our analysis. I also had to take a test about that instrument, a test about gunshot residue overall, and then following all of that, I also had to take a competency exam.
Okay. And can you tell us, you mentioned that you also supervise?
Yes, I'm the manager of the department as well.
How many individuals do you supervise?
Right now, just one.
And so you're responsible for their overseeing?
Yeah, what it is, bro.
Yes, absolutely.
And how many times have you ever testified?
No, you always rock with me. I appreciate it, man.
84 previous times.
And in the state of Florida?
Yes, I believe 13.
You know, a lot of people still think that
Yes, I've testified in 20 different states as well as Puerto Rico.
if you don't have a lot of viewers, that means your content ain't good.
Entire professional career in the
And we already know that's the furthest thing from the truth.
Yes,
Really
it
one of
has
the best niggas on
Can
YouTube.
you explain to the jury what is gunshot residue, commonly referred to as GSR?
Yes, so gunshot residue in the broadest sense of the term is referring to all of the particles that result from the discharging of a firearm. However, when I am talking about gunshot residue, I am referring specifically to the particles that come from the primer, which is one of the parts of the cartridge.
Okay. And what is the primer? And you can give us kind of a summary because we did hear from an expert yesterday regarding this.
Sure. So when you're thinking about a cartridge, it has the projectile or the bullet in it. It has gunpowder.
Oh man, so she here to back up the testimony from the guy yesterday because that shit was terrible.
Inside of there is a mixture called the primer, and that contains a couple of different compounds that together contain the metals of lead, barium, and antimony.
So lead, barium, and antimony.
Yes.
Okay, we'll remember those three. So how is it that gunshot residue is produced and deposited in a manner in which you then analyze?
So whenever a firearm is discharged and the trigger is pulled, this causes something inside of the firearm called the firing pin to strike the primer cap. So it'll hit the bottom of that cartridge and this will start a reaction. So this will cause the primer to burn, and the burning of the primer causes the gunpowder to burn. So as the gunpowder burns, there is a buildup of high heat and as a result, high pressure
I'll be right back, y'all.
inside the firearm. And that buildup of pressure is what ultimately will expel the bullet from the firearm. But because of that buildup of heat, those different elements I mentioned, such as the lead, barium, and antimony, are also going to heat up and become a gas. And this gas will exit the firearm through any available openings in the form of a vaporous cloud called a plume. So you have this gas exit the firearm, and it's now much cooler outside of the firearm than it was inside of the firearm. So those different metals will cool down and combine together and form particles, and those particles will land on the area surrounding the discharge, and those are the particles that I am looking for in my analysis.
And in general, how far is that gas traveling?
It depends on the environmental conditions. Things like weather and airflow can play a role, but in static conditions, typically about 4 to 6 feet.
Okay, and you mentioned the particles. What are the particles that are being produced by the discharge that you're looking for?
So there are 3 different types of primer-related particles. So the first are called particles characteristic of gunshot residue. And these would be particles that have lead, barium, and antimony all together in one particle. So these are considered characteristic because there are very few other sources of these particles aside from the discharge of a firearm, and it is the presence of those that we need to have to be able to call a sample positive for gunshot residue. There are also what are called 2-component particles, which would be any particle that contains two of those three metals. So it could be lead and barium, or lead and antimony, or barium and antimony. And these two component particles also can come from the discharge of a firearm, but there are other sources of them. So when they're found by themselves, they're not as conclusive to the presence of gunshot residue because they could have come from something else. But if they're found in combination with particles characteristic of gunshot residue, they're more likely to be from the discharge of a firearm and are kind of acting as part of that GSR population. And there is a third type of particle, which is just a one component particle, which would be lead by itself, barium by itself, or antimony by itself. And these also come from the discharge of a firearm, but there are even more other sources of those particles to where they're not very conclusive to the presence of gunshot residue. So we, our JUVY group, do not report on those. We are just reporting on the characteristic particles and the two component particles.
And that's because, for instance, lead can be found in paint.
Yes, absolutely.
So the presence of lead in and of itself isn't indicative of GSR.
Exactly.
And can you describe for us how you perform the analysis? And I know you brought up the microscope, which was briefly mentioned yesterday. Can you describe for us how that microscope works and your process?
Yes. So we use an instrument called the scanning electron microscope, which is also referred to as the SEM for short. So this is a very powerful microscope, and it is computer controlled. So instead of looking at your samples through an eyepiece, like you would in a traditional microscope, you're actually looking at them on a computer screen. And this instrument has the ability to magnify by thousands of times. And it also allows you to see the chemical composition of what you are looking at. So because gunshot residue is extremely small and not visible to the naked eye, and is made of very specific elements, that's why we use the SEM. And the way our analysis actually works with it is two parts. So the first part is an automated analysis. So I will take the samples and put them into the microscope, and I will set up parameters on the computer telling it, here are the samples I have, here's where they are located on my sample folder. From there, the computer will scan the surface of those samples, looking for potential gunshot residue related particles. If it comes across something that it thinks could be gunshot residue, it will stop and take a picture of that particle and also save the coordinates for where it is located on that sample. So it will finish going through and scanning all of the samples, and after that, I will do the second part of our analysis, which is the manual analysis. So I will go back to those particles that the instrument flagged, and I will examine them. So I will look at their shape, and I'll see if that's consistent with gunshot residue, which would be something that is smooth or round in shape as the result of a high heat reaction. In addition to that, I will look at the chemical composition of those particles and make the determination for what type of particle it is that I am looking at.
And the automated process is performed by the SEM, right? The SEM for short.
Yes.
And what is it looking for? Those particles that we discussed earlier, or the compounds, the barium?
Yes. So basically, the way the SEM works is kind of based on brightness. So the more dense something is, the brighter it will appear. Because lead, barium, and antimony are heavy metals, gunshot residue related particles will appear very bright. So it's scanning the samples based on brightness. And if it finds something above a certain brightness, that's when it will stop and collect a spectrum to determine what elements are in there. If there's lead, barium, or antimony, or any combination of those, that's when it will save where it's located and take a picture of that particle.
And would a demonstrative assist in your testimony to the jury as far as what the SEM shows?
Yes.
Again, ladies and gentlemen, the witness is going to be using a visual or demonstrative aid to assist in explaining or illustrating her testimony. Just remember that the testimony of the witness is the evidence. However, this demonstrative aid is not to be considered by you as evidence in the case unless it's later received in evidence. and you cannot use it as a substitute for evidence. Only items that are actually in evidence will go back to the jury room during your deliberations. You may proceed, Counsel.
Thank you. And without getting into the actual results, we're just going to orient the jury to the chart that I have here, beginning with the top left.
Yes, so the top left is an image kind of showing where the particle is located on the sample, and that is taken at 400 times magnification.
And the top right.
That is now a closer up image of that particle, taken at 3,200 times magnification, where you can see clearly that it is bright, it is round in shape, and you kind of are able to visualize really the morphology of that particle.
And bottom left.
So that is what is called the EDS spectrum. Basically, it's just showing you what elements are present in that particle. So PB is lead, BA is barium, and SB is antimony. So you see the peaks for all of those present in that particle. Therefore, it is a particle that contains lead, barium, and antimony, which makes it characteristic of gunshot residue.
And are the peaks that we see consistent with the amount of
I bet y'all had to give me something to eat, man.
compound within the sample?
Yes, overall, the height of
I'm
the
fucking hungry as a bitch.
relates to how much of that element is in the particle.
And finally, the bottom right.
So that is the image that the instrument takes during the automated analysis.
And did you receive a sample in this particular case for analysis?
Yes, I did.
Your Honor, urging defense counsel, which they previously not the state's LLL for identification purposes. Your Honor, urging to approach the witness.
You may.
And if you said handle anything biological, there are gloves right there, and the top has been open for ease of access. Tell me if you recognize it first, and if you need to open it. If you could just keep it out.
Yeah, they don't even know where the shooting happened at, y'all.
Recognize it. How is it that you recognize it?
This is one of the items that I received in this particular case.
And it was one sample, and what did that sample contain?
It contained a collection stub labeled as coming from the inside of a Jeep.
Okay, and is that in the same or substantially the same condition as the last time you saw it?
Yes.
Your Honor, at this time, the state of you into evidence, mark the state's LLL as the next number.
No objection. Thank you. It'll be admitted. What's the next number? 60. 60 in evidence. Thank you.
Okay, grab some gloves and we'll start.
I bet I'm back up away from my fucking mic.
This is being published, states 57.
Yeah.
And the contents. So you received one sample, but there are two tubes.
Yes.
What are they representative of?
These were samples that we had received that are labeled as coming from the right hand.
They spending way too much time on the science of the case, man.
Cortland Henry.
They should not have spent 2 days on this.
And you can put those back in.
Or a day and a half.
States 60.
Yeah, we 4 days in. And they still haven't presented any evidence to tie Melly to the shooting. Not an ounce of evidence.
And we have one tube, and what is that representative of?
It is labeled as coming from inside of a tube.
Just leave it, it will adjust. Thank you. You can put it back in and keep your seat. Ultimately have a chance to analyze and go through this process, which is an automated process and your individual process, in order to come up with an opinion as to the presence of GSR.
Yes.
And what was that? And you can specify both the left and then the right.
So the right hand of Cortland Henry contained 0 particles characteristic of gunshot residue and two component particles. And the left hand contained 1 particle characteristic of gunshot residue and 1 2-component particle.
And can you explain to us what that means?
I was ready to say, who the fuck know what that means?
There was gunshot residue present on the hands.
Okay. And what affects the presence or absence of GSR on a person's hand or any object?
Sure. So if there is gunshot residue on someone's hands, that means that the individual got it on themselves by either discharging a firearm, being in the proximity of a firearm when it was discharged, or by coming into contact with a surface or object with gunshot residue on it.
That's reasonable doubt, again.
And go back to the demonstrative aid. What was this demonstrative aid?
More reasonable doubt.
Was this representative of your results?
Can't give nothing definitive.
Yes, that was the particle characteristic of gunshot residue that was on the left hand.
And the components, which you explained before, there are three kinds or 3 compounds that you were looking for, and which compounds were present in Cortland Henry's left hand.
Lead, barium, and antimony.
So all 3 components.
Yes.
Okay, and let's move on to stage 6, which was the sample of the G. What were your results? And again, you will also go through the SEM automated process and then your individual characteristic process.
I did, yes. So there were 0 particles characteristic of gunshot residue, but at least 9 2-component particles.
Okay. And what does that mean?
So, like I mentioned, 2-component particles can come from gunshot residue, but they also have other sources. So, because of that, these results are basically inconclusive. They could be gunshot residue, but they also could be from something else, and I can't say which it is.
Okay. In your analysis and reviewing the sample, did you find anything inconsistent with gunshot residue? If I'm phrasing that correctly.
Correct, and I did not. So overall, with 2-component particles, or any of the particles we look at, if they oftentimes
Put a P on his hands, y'all.
Another source. There are other elements or amounts of elements that would be.
Peel your hands, get rid of gunshot residue.
So, for example, one common source of 2-component particles is brake pads.
Urine gets rid of it.
Contain high amounts of the element iron. So if I'm doing my analysis and I come across particles with high amounts of iron, I eliminate them and I do not report them because there's something about them that would suggest they're from something else. So while I still cannot call these particles gunshot residue, there was nothing about those particles that were unusual.
And I want to ask you about
More reasonable doubt.
test. Are you familiar with that in general?
I am.
Are you familiar with the friend or foe presumptive GSR kit?
I am.
What is that kit testing?
That kit is looking, like you said, a presumptive test that is looking for the presence of nitrates, so nitrogen-containing compounds.
So So for instance, these GSR kits are made to essentially alert to the presence of a certain compound.
Yes.
And the friend or foe kit specifically alerts to the compound of nitrogen particles.
Yes.
So the presence or absence of nitrogen particles.
Correct.
And are presumptive tests relied on exclusively?
No, they are just a screening tool. Like I mentioned, they're looking for nitrates, and there are many things that can contain nitrates. So they are not conclusive to the presence of gunshot residue or gunpowder. They are really just to be used as a screening tool.
Your Honor, members of the court,
Yes.
nothing further.
Counselor Zink Ross?
Yes,
You're ready to proceed.
thank you. Good morning.
Good morning.
I don't think we've had an opportunity to meet. You've got the sample and the sample.
Like she
from
nervous.
Miramar Police Department,
Yes.
specifically, Detective Moretti, directed to you.
Yes.
And when we talk about GSR, or gunshot residue, you're aware that GSR can be found on clothes, right?
Yes, that's possible.
Did Detective Moretti send you any clothes of Cortland Henry?
He did not.
He didn't send you any of the clothes?
No.
Did you know that the clothes of Cortland Henry were collected by the Miramar Police Department?
Objection, calls for speculation outside the scope of trial.
Well, I don't know that calls for speculation.
How you gonna object?
Were you
Yeah,
aware
right say.
that
The fuck? They crazy as
Police
shit.
Department collected Cortland Henry's clothes?
No, I was not aware of that.
But you, in your examination, had you received clothes, you could test those clothes for GSR, correct?
Yes, we can certainly test for everything.
And you've done that many times, correct?
Yes, absolutely.
Also, if someone is in a hospital, in a bed in a hospital, do you know if that person has washed their hands?
I know.
Okay. And by washing your hands, you can get rid of GSR, correct?
Yes, hand washing can remove most, if not all, of the particles on someone's hands.
Do you know if Cortland Henry washed his hands or changed his clothes?
I don't know that.
Yo, none of this shit got anything to do with Melly, y'all. I can't believe they had this nigga sitting all these years for this.
Thank you very much.
Any regret?
Y'all see what I said yesterday?
Is hand washing?
Hey, yeah, remember what I said yesterday? You could tell if the defense think the state got a strong case by how long they interviewed the state's witnesses. Every time the state brought up a witness in this case, they only interviewed them for like 5 minutes, if that. Like they know the case is flimsy. Shit fucking flimsy as a bitch.
Only thing
Like a paper plate.
that removes gunshot residue?
No, gunshot residue is easily removed in general. So with respect to the hands, any type of activity, touching or use of the hands
Yeah.
can remove particles.
That's why I told you
easily.
you could pee on.
With clothing, any activity. So if the garment is touching things, if it's laundered,
If it's removed?
yes.
And the reason why I say yours, cause both sides, if you're in a situation like that, you ain't gonna have time to wash your hands before you go to the hospital, but you can pee real quick. She said accidivity, it's acid in your arm.
Any activity can cause particles to be disrupted or removed.
And you're an independent lab. correct?
Academics ain't gonna tell you that.
You're not associated with Miramar Police Department.
Correct, we are not.
You're not associated with the Broward Sheriff's Office.
We are not.
So you can only test what you're submitted, correct?
Correct.
One question. You were hired by the Miramar Police Department to perform this test, correct?
Yes, they're the ones that submitted the samples.
Thank you.
He petty as shit.
Thank you very much, man.
You see, they was just trying to nail that certain point down. That's all that was. About they didn't test everything. That's all it was about.
Thank you. Can I see sidewalk, please?
He the best lawyer right here, y'all.
Something showing up on the screen and you think you want a better view of it.
You see, he taking the back seat. He ain't even got work on this case. He letting his underlings take care of it.
As included on the file from Snapchat.
Yeah, I saw those. I'm not talking about that, huh? I'm talking about the actual videos.
So do you want to see the images larger as well, Your Honor?
Yeah, I'd like to know what you're going to show to the jury. They're objecting to it, saying it's not relevant. I don't believe there's an objection that's not authentic, that it's not his account from Snapchat.
So the jury must not be in the courtroom right now.
If that's the case, but my understanding is they're saying it's not relevant.
This is the one that I indicated would potentially have the items the defense didn't want in, such as the names of the songs of the defendant.
Oh man, come on now.
We don't have to concern ourselves about that to say agree.
That's irrelevant as a motherfucker.
Image of the defendant. An image of the defendant and Mariah Hamilton. Image of the defendant.
Now, you're saying that this is the defendant and Mariah Hamilton, and I haven't heard anybody identify her yet. Is that, I mean...
Correct, that's why the next witness should do that.
Okay, so the witness is going to do that.
Yes, Your Honor. There she is again. That is Ms. Hamilton. This is the Snapchat logo of the defendant.
But what's the relevance to this? I'm glad it's ugly as shit.
Moving on to the videos.
I never bought them bitch.
This video here is before the homicide. It includes the defendant and one of the victims, Christopher Thomas. There is volume to it. I don't know if the TV is turned down.
Gary, can you check on that?
That's good. That's 63 or 62. There's the volume.
Yeah, that couldn't have been the Snapchat they was talking about. I hope that wasn't it. Just listen to a song. Wow, are they serious? Listen to Fredo Bang. Yo. They can't be serious as that. They can't be serious with that.
This bitch look like he got 5 kids at the school pickup right now, waiting.
Your Honor, for the interest of time, should the state be proffering the relevance of each video as we go?
No, thank you. I'd just like to see it and see what they're
Right.
my understanding. Well, go ahead.
Go ahead.
Right.
It looked like he with Fredo Bang. He might have just been previewing his new song. I told y'all on the first video, they try to assassinate this character. That's part of their defense. They don't have no evidence. Now, he could have been talking about anything right there.
Yes, sir.
All right, so, Counsel, I want you to tell me your complete objection so I fully understand what you object to on the videos as well.
The relevance.
The remaining portion of this Snapchat under this triple
Your Honor, our first objection would be relevance.
Yeah, it's no relevance to the case.
I think Florida statute
Other than character.
401 defines relevance as evidence tending to prove or disprove a material fact. There was not a single video that you witnessed there that implicates in any way any fact in issue.
At all.
I want the court to be
They getting embarrassed, man.
aware of what a Snapchat account is versus a video off of a phone. They're two different things. You can access that Snapchat account from your computer that's right before you. So a Snapchat account or any social media account is not particular to a device. This is contents from an account that exists in the cloud or on the platform of Snapchat and is not peculiar to a particular device. So it doesn't identify a device. It identifies a social media account. The notion...
Now who the hell is this attorney at that time? Why they put them women out there to get embarrassed like that?
Is an issue of...
Because of this rinky-dink ass case.
It's not a relevancy issue. None of those videos I haven't heard, and I think that probably we're putting cart before the horse by making me object to the relevance before she advances her theory of relevance. But the fact is, unless I'm missing something, there is nothing there that concerns the events of October the 26th, 2018, in anything. As far as the messages are concerned, it's similar.
Now we're talking about what's in writing, correct?
What's in writing is essentially a dump from that account, a selective dump, I think from August the 3rd through some date in November. If the state is indicating that there are messages there that relate to the offense, then the state should isolate those messages and make its argument as to what the relevance of those statements is.
I gotta go back and see the first video I did on this show.
Dump all statements that somebody makes since birth until the time of their trial, and because it's non-hearsay because it's a statement of the defendant. And by the way, these are exchanges, so a relevancy objection, a hearsay objection relates to the statements of the defendant, not the ones that are made back to him in any kind of conversational exchange. Those statements themselves are hearsay because they aren't statements of the defendant. And I'm making this argument assuming, because I'm dealing with relevancy, assuming that those
I don't know, JR.
are the statements of the defendant.
The case look featherweight.
Which I'm not conceding.
Case look featherweight, man. I ain't a fan of his music either. But I'm also not a fan of the system putting trumped up charges on black people.
Statements that I observed that seem to be some...
I'm bigger not a fan of that than I am of him.
Conversations between him and any person that...
They got this man facing a death penalty on his weak ass case.
Because of the manner in which he communicates.
Case weak, bro.
How is that relevant to this case? So relevance is number one. A statement has to be relevant. So each statement...
They haven't brought now one piece of evidence Ynw Melly to the case in 4 days. Which means they don't have any. So why was this man locked up for 5 fucking years?
All his statements, and this is a business record exception, therefore they get in, doesn't cut. As far as authenticity is concerned, that's our relevance objection. Relevance must be established. I'll cite the court authenticity issue or authentication issues concern Rule Florida Statute 9.901. And I'll cite the court to some case law that doesn't necessarily deal with social media, it deals with...
So people that just tapped in, yo, he is objecting to these Snapchat messages that the state was making it seem like for years was concrete evidence.
Which
But they just showed the video of the messages,
concerns
and it don't, or the
text on a
videos,
cell phone.
and it's nothing.
And it indicates, these were some notes that I took down because I didn't realize.
Nothing tying him to these murders.
Trying to bring this in today. We had asked for some indication as to the witnesses. And I think this is the only day we didn't get any indication. And so there's an element of ambush. But nonetheless, in the Simonette case, it stands for some legal principles that were articulated in that holding that I took note of. One, in that case, there was concern regarding the admission of screenshots of text messages, communications. And the court said it was okay because there was a witness that testified that she was sitting next to the defendant in a car when the texts were made. And the detective recovered the cell phone from the defendant, and the witness identified the text messages between her and the defendant. In other words, there was a party to the communication who was able to authenticate the communication and who the participants are. Another case is Roy, which is 279 Southern 3rd 238.
279 what?
Southern 3rd 238, which concerns emails and texts. And these were emails that were admitted through the investigator that was posing as a 14-year-old in what appears to be a case that concerns some sort of a pedophile sting. And the investigator involved in the exchange, the investigator was involved in the exchange of the emails of the text. One of the quotes that I took from that case says, most common way to identify social media, which would be this, and things akin to social media, is to let the author testify that they're the ones who generated or created it. So there's somebody that is involved in the exchange of communication that can attest to the fact that they created it or were involved in it and identify the parties that were involved in the exchange. When a participant is used to authenticate electronic exchange, the focus is on the witness's ability to identify the person against whom the communication is offered. In criminal cases, the person communicating with the target of the investigation must be able to identify the target through some personal knowledge or experience. So this establishes that there has to be somebody who participated in the communication, who authenticates the participants in the exchange, and must be able to identify the participants in the exchange. In the Roy case, the sergeant, who was posing as a 14-year-old, acknowledged that he had no idea who was on the other side of the emails and texts. Here we have nobody at all, let alone somebody whose knowledge is insufficient.
This is just a PC affirm case. These opinions are, right? Am I reading this right? This is a PC affirm. That's in the concurring opinions or?
I can print it out if you
I'm reading it right now.
I'm not sure that what the court is.
It's a PCA affirm.
Meaning the language that I'm reading doesn't exist.
Not that it exists, I'm sure it's there. I didn't read the whole concurrent.
Okay,
But it's a PCA affirm.
Well, maybe I cited it incorrectly.
Oh, you cited it right. 279, Southern 3rd, 238. All right, go ahead.
Okay, this is language I took from the cases themselves.
I don't doubt it. Okay. Seems like it's all here.
Okay. I'm not sure.
He don't like the
That's
the
not
lawyer.
in the court.
Yeah, that's one thing I'm gonna tell y'all.
That's what his concurrence was. Is it?
Them small town judges don't like big time lawyers. I think that might be universal. You know what I mean? When you fighting certain cases in small towns and you bring a big time lawyer in there, they gonna give him a hard time. Straight up. I ain't saying that shit dumb before. They don't like that shit.
His or her opinion, and there's another judge who has a different concurring opinion. There's no specific majority opinion. I don't see one. The other concurring opinion says he'd reverse. But it's a PCA affirm.
I'm not quite sure the significance of that, but I'm sure the court has a message that's communicated. No evidence that the texts were recovered from a phone, A, belonging to, in the possession of, the appellant pursuant to a search warrant, is another quote. Further, in that case, the sergeant could not identify appellant as a person on the side of the emails or on the other side of the emails or texts. Lamb versus State, 246 Southern 2nd 400, a 4th DCA case in 2018. A quote that I took from that says, the case involving authentication of a Facebook video, or videos here, is also instructed. In that case, the 4th District recognized a distinction between authentication of a video recording and an audio recording. An audio recording would be more akin to a communication that you can't tell the identity of the communicator's visual. The 4th District acknowledged its prior holding that authentication of an audio recording, quote, should be made by the technician who operated the recording device or a person with knowledge of the conversation that was recorded. Quoting Santana versus State 191 Southern 3rd 946, which is another 4th District case. So as far as authentication is concerned, Your Honor, and the PCA affirmed component, notwithstanding, the articulation that is being made repeatedly by district courts of Florida, this state, and by the 4th District, are that when you are introducing text messages, communications that are in print, audio, somebody has to identify the participants. You can't just put them in and say, this is the guy who said it. You have to lay a predicate of authentication.
Basically, he's saying, regardless if them texts came from Melly's account, they got to be able to prove that Melly wrote those messages. And we all know they ain't really no way they can do that. But I doubt if the judge agreed.
Which the state is not attempting to. So as far as relevance is concerned, they have to establish relevance of each statement. They can't just say, here are all the communications he ever made, and notwithstanding who he's making them with, whose statements are themselves hearsay, because his statements are statements of the defendant and therefore not hearsay, non-hearsay by definition, they come in. They have to establish the relevance. So we object. One second.
Judge ain't gonna rock with that. I'd be surprised.
So the communications are not particular to a phone, so it doesn't meet that hurdle. They are particular to a social media platform. A social media platform that they have to establish belongs to the defendant, and I don't think they have said how they purport to do that. Even if they do that, the statements of anybody else in those exchanges is hearsay. Statements of the defendant are irrelevant, and the photographs and videos are also irrelevant and prejudicial pursuant to 90.403.
Thank you. I misspoke. It was one opinion. It's a PC affirmed on Benjamin B. State, or Benjamin D. Roy B. State, that you cited 279 Southern 3rd 238. It's a PC affirmed. There is a concurrence, and he would concur in part and would reverse in part. I misspoke. All right. So yes, Counsel, you want to be heard?
Yes, Your Honor. With regards to, and defense counsel already has the Lamb State films for the printed copies, Your Honor. Specifically, authentication for the purpose of admission is a relatively low threshold that only requires a prima facie showing that the proper evidence is authentic. I'm reading on the 9th page of notes 5 and 6. Your Honor. Lamb case goes on.
I could never be a prosecutor, man.
Authentication for the purpose of admission is the ultimate determination of question for the fact finder. Evidence may be authenticated by appearance, content, substance, internal patterns, or other distinctive characteristics taken in conjunction with the circumstances. In addition, the evidence may be authenticated either by using extrinsic evidence or by showing that it meets the requirements for self-authentication. With regards to the evidence that's before Your Honor, the defense is not agreeing that it's his account, so then the burden is on the state to prove that it's his account. As such, the evidence itself shows that it's authentic, as it is the defendant in every single one of those videos. In terms of the contents of the defendant's statements, they are relevant. They go to the issue of that fact of whether or not he committed these two homicides. The contents of the questions are important for giving context. An answer without any context doesn't give the fact finder, the jury, any way to meaningfully evaluate the statements. So based on the standard, which is low for authentication, the state has done that by the business record certification, and the fact that the email address and everything else will be linked up in other witnesses as well, showing that that was the defendant's particular iCloud account that is the username. It's also important to note, Your Honor, that while the individual doesn't tie it to a specific device, it ties it to a specific individual because it's a unique logon and username and password, just like an email account, that it was used by this defendant.
Thank you. Anything else, counsel?
Yes, Your Honor. There are statements there that, in the conversations that started on October 3rd. October 3rd, this incident occurred on the 26th. The state is making a blanket assertion that these statements go to demonstrate his complicity in these homicides. Each statement has to be identified and the argument has to be made as to each such statement by itself so the court can have a way of evaluating the purported relevance. They can't just say they're relevant to the homicide. That is insufficient. And if they do not identify each particular statement and the relevance of each particular statement, then dumping them all in on some blanket assertion that they're relevant would be error, and it would invite error, and it would prejudice Mr. Evans irreparably. So, context for what? He's having an argument, a discussion with somebody on October 3rd. If they're saying that that constitutes some plan that establishes premeditation, then advance that argument. They have not referenced a single one of those conversations with specificity and advanced some argument that ties it to a facting issue in this case. So I would say that on the relevance alone, the state fails to make a showing that would allow the court to even properly analyze the question at issue.
Thank you. I'm going to throw everything out. Take a look at your cases that you just sent. We're going to take a short recess. Mr. Demings, any restroom break? Yes? We'll be in recess. Thank you.
I bet y'all had to take care of something.
Or to establish that it is the account of Mr. Demings. I'm just putting on the record that the defense would be willing, if she does,
Council's gonna take you 2 minutes.
yes, give me a few minutes. Maybe Mr. Allison is taking a piece. We just wanted to be clear that if we are,
So, you want to be on the record again?
yes, just so I can complete the record on this one point.
Let the record reflect the presence of the defendant, his counsel, his state attorney, yours and your, yes, sir.
The state is asserting that among the conversations in State's Exhibit, what was it, mark for identification? Triple J, that there are certain conversations or certain exchanges which she believes relate to facts at issue, and that the rest of them she is using to authenticate or to establish that it is the account of Mr. Demings. I'm just putting on the record that the defense would be willing, if she does isolate those conversations, to consider not objecting or not making the claim that it's not his account, so that she can get in whatever she deems is relevant, and we can avoid the prejudice of the remaining contents that she intends to put in that is not relevant, and she only intends to put in to establish that it's his account. I just wanted it to be clear that that is an offer that we have tendered to the state, and we're articulating for the board. Thank you.
Thank you. What's the state?
The state is going forward that the state has to convince the jury beyond a reasonable doubt as to the authenticity and who those messages link to. And that was the way defense counsel indicated from the beginning that is how the state needed to proceed. So at this point, the state would enter the evidence as it is currently posted.
Thank you. You please consider, I mean, there's whole conversations with Ms. Mariah.
I knew the judge wasn't going side with the defense.
To authenticate the who's accounted, but I don't know that it does anything other than that. Can I see the exchange again, please? JJJ.
Oh, I left it right there, I'm sorry.
And Mr. Edelstein asked me to print another copy for him, so I'm trying to work on that.
I'm sorry.
Look at them little desks they got in there. Y'all ain't never see a courtroom look like that. And Baltimore City Circuit courtrooms and Baltimore County courtrooms, nigga, them bitches is up to date, high tech. You can't push a desk in that bitch. I think I might have been at every Baltimore City and County court, district, circuit, Mitchell, fuck it, Hartford, the downtown courthouse. I think I've been in all them bitches. Wilkins Avenue. I've been to Patapsco. I've been to Patapsco too.
Some way, shape, or form, if it's not him, if it's limited to what the state is
See if they back yet.
conversations between he and his girlfriend and things like that wouldn't come in. Is that what you're saying?
I am saying, Your Honor, that if we need to be able to make an informed decision. So I am saying that we need to know what she deems to be relevant, and then when we know that, then we can make the decision that, okay, well, we think that it makes more sense to not make the argument that it might not be his account,
Okay.
so that she can get our evidence in, but to get the rest in. Your Honor,
No problem. We'll just leave it the way it is.
okay. There may be another issue, not as though I, have enough on your plate here. We have reason to believe that the state intends to call Miss Felicia Holmes in this next session. And there is the law in this jurisdiction and in this state is that a witness shall not be called merely to be impeached. I don't know that that is the case or not, but I am concerned with trying to unring a bell. The theory is essentially a statement that the state knows that they will not be able to elicit, and they seek to only impeach their own witness by a prior inconsistent statement, amounts to hearsay because it's being offered for the truth of the matter asserted. So when the state calls,
I think you're gonna get found not guilty, Southside.
Is about to, and these are
They don't have no evidence on.
Witness says A.
They got more evidence on Portland than they got on Melly.
And the state wants to get A in and knows that the witness's current position is B. Put the witness up there to say B and then impeach them with A is improper. I have here some cases, a few, for the court stand for that position. WB State 545 Southern 2nd, 857 Florida Supreme Court 1989. Felton v. State 120 Southern 3rd, 126 Florida 4th DCA 2013. Curtis v. State 876 Southern 2nd 13 Southern 2nd 13, and that's first DCA 2004, and there are many others. And may I hand up? I have highlighted copies of the cases.
You have them for the state as well?
I do indeed.
Take a look wherever you have.
Thank you, sir. Now, I understand that this might be a little bit premature to the extent that I don't know for what purpose they seek to call Ms. Hamilton, but I don't want to be in a situation where we're trying to unring a bell when we are in a position to avoid that prejudice from occurring. So I'm alerting to the court to that possibility, and if that is in any way the state's intention, I would ask that it be voiced now so that the court is in a position to make that assertion. And they don't even need to voice it to us. They can voice it to the court outside our presence.
Who's your next witness?
Felicia Holmes,
All right, so it is Miss Holmes. And,
not Miss Hamilton.
Felicia Holmes, sorry.
and what do you anticipate Miss Holmes saying?
I believe she was testifying consistently with her previous statement that she gave in 2018. And I'm very familiar with the case of the state council. The state council called a witness just for the purpose of impeachment. However, I'd also direct your Honor's attention to 9803 subsection 5, past recollection reported, in which a witness who no longer has a memory of an event, but has previously given a memorandum or record as to what happened, they may testify as to like
telling me that you believe that your witness is not going to remember what you said previously?
I believe there are instances in which her memory is no longer available, and that she would testify that she was truthful to law enforcement at the time of the statement in December of 2018, which she now no longer remembers because it has been so long.
Yeah.
And that was a time when her memory was better, it was closer in time to the time of the offense. It was within 2 months of the offense occurring and the offense of which she witnessed, so that would be admissible under 1903
So you're telling me you spoke with her, did a pre-trial discussion with her, and she said she has no memory of what she said at the time?
There are parts of it she doesn't recall. That is correct.
May I retort? Okay. A couple of things. One, as with every other witness, the way that you prepare your witness is you refresh their recollection before you call them to the stand. So the notion that this witness is going, that all the state has been able to glean is that Ms. Holmes no longer recalls something which she said several years ago, and the state has not sought to refresh her recollection, in which case she would have been prepared to testify. Then the pretext that she comes in here and says something different, and then she impeaches her with a prior consistent statement, claiming that it's an effort to refresh her recollection, is disingenuous and in bad faith. And if that were able to be done, then this body of law would not exist. We also took her deposition, Ms. Holmes, on December 14th of 2022. No, that's not it. Much more recent than that. No.
2010.
December 2022, in which Ms. Holmes receded from the statements to which the state refers firmly and unequivocally. And the state is therefore, I think the language used in a lot of cases that I have cited and in a lot of cases on the subject is the state needs to be surprised during the course of this examination at the contents of the statement in order to thereafter impeach their own witness. This notion that, oh yeah, well, she forgot, and while we talked to her, we learned that she forgot, and instead of refreshing her recollection, as we did with every other witness that we put forth prior to in preparation for her testimony, we're going to wait and do it on the stand by impeaching her with a prior inconsistent statement is a pretext, it's in bad faith, and it's improper. It's prejudicial, and it should not be permitted. Essentially, it amounts to hearsay, because it's a prior inconsistent statement or a prior out-of-court statement that is going to be used to prove the truth of the matter asserted, which is different from impeachment, where it's not used to prove the matter asserted, it's just introduced to prove that you said something different at a different time. I think these cases are clear. And if that's what they intend to come and do, again, they're inviting error, and I'm alerting the courts and the state to it before this miscarriage of justice ensues.
Thank you. Any other comments?
Just the record's clear in her deposition, she says, I don't remember, or I can't remember, approximately 26 times. The witness has been reviewing her statements and deposition for the past 2 days, and she still persists in saying she does not remember, so that 98-305 would be an appropriate remedy to enter the testimony from the prior statement.
By the way, Your Honor, I've highlighted those cases for ease of reference. Or at least 2 of them.
What's her statement, counsel?
What is her statement?
Right.
This was previously provided to defense counsel.
Oh, just give me a synopsis.
Yes,
What is it that you want, or if you believe she's going to testify to, or if she doesn't remember what you are going to try to refresh her recollection?
So she says that she was woken up at 4 in the morning. Her daughter was screaming. The daughter was on FaceTime with Melly. Mr. Dimmons then says he was saying that Mr. Dimmons was saying that someone just shot the car up and was trying to shoot them. He then said there's like a car coming behind them and he's hiding. So then she asks Mr. Dimmons, "Are you okay?" His response was, "I'm okay." She then asks him where are Sack and Juvy, the common nicknames of the two victims, and he said, "I don't know if they're in the car. I think they're dead." So she then says, "You think they're dead?" She then goes through and describes her actions and conduct. She said that she called his mother, Jamie. Oh, I wouldn't go into the contents of that conversation because that would be hearsay. She then describes what she sees, which was her daughter on the phone on FaceTime with Mr. Dimmons. She then says that she's going to come down, and then she describes her actions, that she hopped in the car and came down to South Florida. She said that at that point she asked and called Mr. Dimmons again, spoke with him and said I'm at my friend Fredo's house. Fredo picked me up, so we went to Fredo's house. Then she describes that Fredo lives over in the same neighborhood that Melly lives in, and that she went in through another gate from the same neighborhood on that one. She then says shortly thereafter in her statement, when they get to Fredo's house, that Melly comes out and he takes Mariah and they go upstairs at Fredo's house. Then she also goes through and indicates that after this incident, that Mariah, her daughter, Mr. Dimmons, Cortland Henry, and Cortland Henry's girlfriend are living together in a condo in Miami. She's going to testify that and the statement also says that she didn't see any blood or anything on his clothes or anything like that. The question is asked then about her being FaceTimed, meaning Mariah Hamilton, the daughter of Jones, FaceTimed, and her answer at that point was, he FaceTimed my daughter from the 772 number. So then she continues on, unless he got rid of that phone, he FaceTimed my daughter that morning at 4 in the morning p.m. Then she's asked, what's her daughter's number? And she gives her daughter's phone number at that time, 321-506-1313. Then it continues on, and so the law enforcement officer asks and says, I have his phone records, meaning that of Mr. Dimmons, and he never called, then she identifies the phone number as, you have the 772-713-9807 number. She then continues on, he called and FaceTimed with, I talked to him on FaceTime. Then there's another incident, I don't know if potentially this could be possibly admissible, depending on the testimony. She says that they told me there were other guys in the studio, and he was saying that the other guys got mad, but they never said who was at the studio.
But you're telling me, counsel, that you spoke with the witness prior to, and the witness is not saying she didn't say X, Y, and Z. She's saying she doesn't remember.
Correct.
The incident.
In the presence of the witness and her attorney.
Thank you.
Before I address the specifics there, I just want to put into the record some of the language that I think is most pertinent in the Curtis case, 876-7-2-113, which is a First District case in 2004. This is the language. It says, Florida allows litigants to impeach their own witnesses, but that does not necessarily resolve the constitutional problem identified in Chambers, which is another case that's referenced. Although a witness may be impeached in Florida by any party, including the party 90.608 Florida statute, it is still improper under Florida law for a party to call a witness merely as a device to place the impeaching testimony before the jury. That is courteous. In the Florida Supreme Court of Dudley, the language that we're relying on, the case says one major issue requiring our consideration concerns the calling of Robert Bennett as a court witness and the presentation by the state of his prior inconsistent statement as substantive evidence. There's language further down. It says, in a similar situation, the First District Court of Appeals in Austin v. State 461 Southern 2nd 1380 Florida 1st District 1984 found that although a witness's hostility towards the parties may justify the trial court's exercise of discretion in calling the witness as a court witness, call a witness only to elicit prior unsworn statements for the purpose of proving the truth of the prior statement is error. District Court stated, under the circumstances of this case, it was impermissible to use the expedient of calling the witness as a court witness under section 90.615 for the purpose of eliciting his prior inconsistent statement, either for impeachment purposes or as substantive evidence. To conclude otherwise would permit indirectly that which may not be done directly. Further language from that case says the fact that a witness may be hostile or unwilling does not mean that he is adverse. In order to be regarded as adverse under this section, the witness must give testimony prejudicial to the cause of the party calling it. So if you know that's what's coming in to begin with, there is no surprise. And then in the Felton v. State 120 Southern 3rd 126 4th District 2013, the language that we're relying on says, in Ruff v. State 31 Southern 3rd 833 Florida 4th DCA 2010, this court explained, our Supreme Court recognized that consistent with federal precedent, a risk of abuse occurs when a prosecutor calls a witness who was previously given a statement implicating the defendant, but who has since repudiated that statement. In such cases, the purpose of calling the witness must be examined along with a balancing analysis on the federal rule 403 to weigh the prejudice over the probative value of the evidence. Generally, however, the party, and that's citing to Morgan v. State 689 Southern 2nd 259 Florida 1997, that was receded from on other grounds. Generally, however, if a party knowingly calls a witness for the primary purpose of
they're back in court now,
which otherwise would be inadmissible, impeachment should ordinarily be excluded. That is exactly what is taking place here. There's no failure of recollection. If the state, first of all, if somebody gets a call at 4 in the morning concerning a murder that occurred, you don't forget it. This notion that she forgot and she is now going to refresh her recollection by reading a statement into evidence that is impermissible, hearsay, is a pretext, and it is a 403 violation, and is a violation of well-established law in the state that I've just articulated. And if the state was unable to refresh her recollection of such a significant event during preparation, the notion that she is now just going to read the statement into evidence on some pretext is a miscarriage of justice. She has a witness. She has a witness. If she doesn't, and she knows she doesn't, calling the witness to impeach them by essentially introducing hearsay testimony is improper. The deposition that we took made clear that she she was receding from the statements that she made, and she gave explanations for why she made statements that she made. This is not a situation of failing recollection. This is a situation where they're trying to put in impermissible evidence under a pretext. We object.
All right, anything else? Madam State?
Judge gonna let that go though.
We're gonna bring it inward and see where it goes. All right, I understand what the, God bless. I understand what the objection is. We'll see where it goes.
All right.
All right, let's bring the jury in.
All right, y'all. Be back.
Citations, I provided a copy to defense and a copy for your honor. And the light is located at 116, 7th 3rd, 270, Florida Supreme Court, 2013.
More than 100 million Americans rent, but more than 97% of renters don't get credit for paying their rent on time. With Self, you can change all that and build credit just by paying your rent. Download Self and get the credit you deserve.
I went on a cruise, and that's where I met the most beautiful man that I have ever seen.
Man, this travel moving too goddamn slow. Okay, crazy as a motherfucker. Where is it? Lies, man, motherfucker. The fuck is they doing, man? Get the goddamn proceedings going. Let's go back to the mother testimony.
Please have a seat. Ms. Holmes?
Yes, sir.
That microphone in front of you does not move back and forth. It will just up or down, but not back and forth.
Okay.
You ready?
Yes, sir.
Counsel, you may proceed.
Good morning, Ms. Holmes.
Good morning.
How are you today?
Not good.
Are you cold?
No, just, you know, I don't feel comfortable.
Are you nervous?
I feel threatened.
So, Ms. Holmes, I want to start and talk
The defense
about...
told her that. Defense told her to say that.
Ms. Holmes, do you have any children?
Yes, I do.
Can you tell the
That speaks volumes to the jury.
is Mariah Hamilton?
My youngest daughter.
And how old is Mariah?
She's 22 right now.
Said she feel threatened.
Mariah, did she have a romantic relationship with someone named Ynw Melly, also known as Ynw Melly?
Yes, she did.
When was she involved in that romantic relationship with Melly?
I think it maybe 2016 or so till maybe 2019, 20.
Okay.
The fuck, she was
Did you
16?
have the opportunity to meet Mr. Dennis?
Yes, I did.
What did you refer to him as?
I call him Ynw Melly.
Do you see him here in the courtroom?
Yes, I do.
Where is he?
He's right here.
And what's he wearing?
A white turtleneck and a gray jacket.
Here may the record reflect the court identification of the defendant.
Yes, record will reflect the in-court identification of the defendant.
So in October of 2018, had you met the defendant prior?
Yes, I did.
How many times had you met him in person prior to that?
A couple.
A couple?
Maybe two.
Okay. Did you follow him on social media?
I'm not sure. In 2018, I wasn't up.
Okay. Did you know if he had social media at that time?
I didn't. No, I didn't.
Did you have a social media account at that time?
Yes, I did.
And what was your social media handle?
I'm sorry.
What was your social media name?
My name. For which one?
For Instagram.
Instagram. It's like Bling Queen 258.
Did you have a Snapchat at that time?
I don't think so. If I did, I may have.
What about your daughter? Did she have an Instagram?
I'm pretty sure she did.
Did she have Snapchat?
I'm pretty sure she did.
So I'm going to show you what's been already admitted into evidence as State 61. There's a couple of videos and things on that I would like to ask you to have some questions about.
Your Honor, we object as to the predicate being laid for this witness to testify to any of this material. Thank you.
So I'm showing you what is titled Memories 2018 October 9th 458 UTC, Melly, Montana. Can you see that picture there on your screen?
Yes, I can.
Okay. Who is the female over there?
That's my daughter.
And which daughter is that?
Mariah.
Okay. Who else is in that photograph with her?
That's Chanel.
I want to go here to this image. This is 2018, November 11th, 23:53:26 UTC. Again, Melly, Montana. Who is pictured in this photograph?
My daughter Mariah.
Do you recognize the individual in the back?
No.
Prior to coming into court yesterday, were you shown two photographs of the alleged victims in this case?
Yes, I was.
Were you able to identify them?
No, I was not.
In terms of your relationship with Anthony Williams and Chris Thomas, how many times have you met them?
Maybe Sack maybe twice. Juvy maybe once.
And do you know them by their real names?
No, I don't.
How did you refer to them?
Sack and Juvy.
Okay. So I want to go forward to some of the videos in this particular exhibit, specifically Memories 2018, October 18th, 2:17:49 UTC. Start with this one.
This before the murder.
So the image that is shown there, do you recognize the person in that driver's license?
It's blurry.
Okay. I'm going to show you another video, the next one. Whose driver's license is that?
That's my blurry.
The
Hope they move.
conversations and things that on there.
Got an hairdresser all on there.
I didn't really, this, I mean, you have to say it again.
Do you recognize the person who's speaking in that video?
Yes, I do.
Who is that?
That's Chanel.
Okay. So I want to go back to October 26th of 2018. Where were you living?
I was living in Cocoa.
And my geography is terrible, I think. How far away is Cocoa from Broward County?
3-4 hours.
What do you do for a living?
Registered nurse.
Were you a registered nurse at that time as well?
Yes, I was.
Did you know the defendant's mother?
Yes, I did.
And who is she?
Jane.
Had you met her prior to October 26th of 2018?
Yes, I did.
Had you communicated with her?
Yes, I did.
Did you have a phone number for her?
I'm pretty sure I probably did.
I'm not asking you, sir.
I don't know, right here, I can't remember.
Okay. So I want to go forward on October 26th of 2018 and talk about early morning hours. Did you receive or hear a phone call or FaceTime video call from which the defendant was assistant?
I did overhear, I'm not quite sure exactly the context of the call, but I did overhear the phone call.
Okay. Tell the ladies and gentlemen of the jury what woke you up that morning.
Just hear my daughter's voice.
Okay. What was the tone of her voice without saying what she said?
I don't remember. I don't remember.
Do you remember anything the defendant said on that video?
Not really, no, I don't.
Okay. Did you have an opportunity to read the statement you gave in 2008?
I read the statement.
Okay.
I don't recall, I don't remember anything from that statement, but I do remember my deposition from
Yeah, he probably paid her a couple of hours.
22.
So the deposition.
But this is what I'm saying, y'all. The state witnesses, why would they continue to bring these witnesses forth? You know, because these are prosecution witnesses. So why would they bring them knowing they're not going to help their case? Like, that shit, it just makes zero sense to me. They've been fighting this woman for years now to go to court. She wasn't trying to go to court. That's why she said she felt threatened. They must have subpoenaed her. For her to go to court and side with Melly. Like, yo, that shit is crazy to me. They're better off letting her stay home.
I remember speaking with them, but I don't.
Alright, try to restart. I ain't start yet.
You have to say it again.
They're saying that part.
I don't remember what I said back. It was like 5 years ago.
Oh, of course. I understand it's been a long time. So in terms of the time frame, that was closer in time to the incident of October 26th of 2018?
If that's where you guys are saying it is.
You don't even remember?
I don't remember, because 2018 was a very hard year for me. My husband just went to prison, my father died, I had a lot going on, so I was really...
Okay. And in terms of your conversations with the police officers that morning?
Yes. I do remember that they kind of bullied me and threatened my daughter and take her to jail for accessory after that. I do remember that.
Yes. And in terms of the statements that you made about what happened. You don't have any recollection of that.
So
Did
basically,
you read this statement multiple times?
what she's saying is, y'all threatened us. So regardless of what was said, it may have been said to get out that situation. That don't mean it was necessarily true.
I looked at it and I just didn't call it, and I, no.
And so you indicated you...
People do it all the time. Said dude plead guilty to a murder he wasn't even nowhere around to commit.
I don't remember what I said to them that day, so if I was to tell you something now, I could be lying. I don't want to lie to stand because you're going to take me to jail. So I'm saying what you want me to say.
I do not want you to say anything, I want you to tell the truth.
Okay, that's what I'm doing.
Okay. So Ms. Holmes, with regards to that day, did you lie to law enforcement?
That's just answer. Excuse me. Hold on. Repeat your question.
I don't remember. Yes, sir.
One person been talking at a time, and there was an objection. I just wanted to.
Okay.
All right. You ask your question again.
Okay. So Ms. Holmes, did you lie to law enforcement?
Not that I called.
Okay.
I don't remember.
Okay. Going forward to the events of that day.
Yes.
When you heard that phone call, where were you?
I'm home.
Okay. Where was in home in Cocoa?
Cocoa.
Who else was there at your house?
My kids.
When you heard the phone call, did you hear what had allegedly happened?
I heard that there might have been a shooting.
Okay. Did you see any pictures or videos of anyone who was injured at that point?
No, I did not.
Did you see the defendant on the screen of that video call?
I saw his face, yes.
In terms of the method of communication, do you know if it was a FaceTime call?
I assume it was FaceTime. I couldn't say for sure what kind of call it was.
At the time of October of 2018 through December of 2018, did you know the defendant's phone number?
No, I don't.
Do you recall today what the defendant's phone number was?
No, I don't.
Okay. In terms of the information and stuff that you have regarding...
I'll get when she come back on
Was
stand.
that saved in your phone at that time?
Oh, she back, y'all.
It may.
Your deposition.
Yes.
You recall that you can provide a copy of that deposition?
Yes, I did. My lawyer got provided a copy.
When you, in that deposition, were you asked if your prior
Objection.
statement...
That's leading.
I heard it. You can ask your question.
Ms. Holmes, prior to that deposition starting, were you given your prior statement to review?
What you mean?
Were you?
I understand. The deposition that I did on December 22nd. Yes, it was given to my lawyer yesterday, right before briefly to look at. Yes.
So the deposition you were have that was provided
to my lawyer yesterday. Yes, it was.
So you remember coming in for that deposition?
Yes, I did. I was in jail. Put me in jail.
Correct. And so it's clear you, in terms of you don't want to be here.
You're making me be here. Yes, I have.
Yes.
I also have a band on my leg. I'm a nurse. I can't even work properly. Yes.
Yes. You were under house arrest because you failed to comply with the subpoena?
No, you did not. Sir,
Are they getting personal?
You ask your questions, counsel.
That's good for the defense.
Answer her question.
Yes, I am. Yes, sir.
Okay. So going back to the deposition.
Yes.
On December 14th of 2022.
Yes.
Do you remember coming to my office?
Yes, I do.
Do you remember being asked questions at that time?
Yes, I do.
Do you recall being given a copy of your prior statement of December 12th, 2018?
No, I don't remember that. I don't remember anything, but I'm pretty sure.
Okay.
They should not have brought. They should not have dragged this woman to court.
With what, counsel?
For deposition.
Objection, Your Honor.
I have to give her an opportunity to...
I saw my
Excuse me. No question pending if you. All right, you can proceed, counsel.
Okay. So, counsel, I'm showing her page 10, line 10 through...
She legitimately scared though, y'all.
Read them silently to yourself. So back on December 14th, 2022, where you asked if you need to make any corrections or deletions to the statement of December of 2018.
That's what the deposition said, usually.
And did you indicate that there was no corrections or deletions in those statements?
I don't remember, but that's what's on the deposition.
So, December of 2022, you said that this is a correct statement.
Objection.
Sustained.
So, Ms. Holmes, is the December 2018 statement that you gave correct and honest?
That's leading, y'all.
Excuse me.
They can't do that. You can't lead into an
I
answer.
don't understand you're trying to answer the question. But when they raise an objection, you have to let me answer the objection first.
Yes, sir.
Objection notice overruled. Question is the statement. What's your question?
Is this December 2018 statement correct and honest?
I don't remember the December 2018 statement.
In December of 2022,
Yes, ma'am.
did you state that it was an honest and correct statement?
That's what you put in the deposition. I don't remember saying it, so I can't remember verbatim what happened. I remember some parts of this deposition, but not all.
Okay, is there anything that you need to refresh your recollection to determine whether or not I'm being truthful and accurate as to what the question was in your answer?
I don't know to say that.
Okay.
Is that a question?
This shit ready to get bad, y'all. Cause she's scared.
Just wanted to let her finish her answer before you ask the next question.
She don't want to get Melly in trouble.
Anything that would help refresh your recollection?
I don't think so. I don't know.
Would the audio of the statement of December 2018 help you?
Objection.
What's the objection?
It's irrelevant. She testified 3 times.
Excuse me. Thank you. Now as to this, go ahead. Overruled.
I don't know. I don't know.
So, Ms. Holmes, with regards to the events of October 26th, 2000,
They're gonna have to play the recording.
did you travel down here to Birmingham?
Yes, I did.
Who did you come with?
My daughter, my wife.
Okay, where did you go?
We went to one of Janelle's friend's house.
And whose house was that?
Frida.
And no approaching was been previously shown to the defense counsel.
Riddle bang in this case a lot, man.
End for identification purposes only. Ms. Holmes, do you recognize the 2 individuals in that photograph?
Yes, I do.
How do you recognize them?
I know Frida from being on Instagram and rapping. He's a rapper.
Okay, any other individual in that photograph?
My daughter's work.
Okay.
I'm sorry. I apologize. I didn't hear that.
I'm sorry.
I didn't hear your answer.
Which one? Do I recognize?
Thank you.
I do recognize Frida from Instagram for being a rapper, and I recognize Janelle for dating my daughter.
You're at this time, state we request in the state's N. N is the next number of exhibit.
Any objection?
Relevance.
Overruled. It'll be admitted.
State's triple N, New York State 62.
If she gonna end up getting herself in trouble though, man. She continue going this way.
This is the photo that you can see on your screen that you just identified? Okay. So when you said Frito, is this the individual's house you went to?
Yeah.
Okay. Ms. Holmes, how much money has the defendant's manager given you since the October of 2018?
Objection.
Damn.
Relevance.
Motion comes out.
There's definitely some relevance. He gonna let that go. I guarantee you, I'd be surprised if the judge don't let that question stand. That would surprise me. Because if she took money from 100K track, that says a lot. That would explain why she is the way she is on the stand. But not trying to be honest and answer questions and being combative. That shit really like that, y'all. They can't. The people in the courtroom can't even hear what they saying. Like when they approach the bench and they turn that little thing on, you really can't hear shit. Up there, anyway. I don't think that's just us not being able to hear. They can't hear in the courtroom either. I guess you would call that a white noise. That black prosecutor look real young. What the fuck is he talking to? Yo, Melly ain't got it all, man. He ain't got it all at all. Rubbing all over his face and shit. They must have told him to do that when the camera come on him. Act crazy. When they put the camera on you, act crazy. Because he wasn't just doing that until the camera got put on him. Yeah, I'm sure that they had to told him that. Come on, y'all gotta fix the audio, man. Can't even hear it. Come on now, y'all. That's their audio. Can't hear the fucking question. Oh, there you go.
To pay for it as far as he gave me $5,000 for Airbnb. I gave him $1,000 to deposit that.
So he did give you money?
Not your personal use.
Excuse me, can we clarify who he is, Jameson Francois? Just clarify, counsel.
So it's clear who is Jameson
I told you, Judge, you're gonna let that go through. Yo, the judge. The judge's goal was to really help the state. You know, they never admit it, but they let the state get their emotions through way more than they allow the defense. So it's really a lopsided system, but it's supposed to be fair. But this question was relevant to the case, so I see why he let it go. I just wanted to inform everybody. That's how I go.
For my AA.
So AA and his wife
We're all good friends.
Okay. So I'm going to now with the previously shown to defense counsel and marked as state triple M. It's a composite of 17 pages. Did you have an opportunity to review that prior to coming to court today?
Yes, I did.
They pulled up bank records.
In terms of the individuals and the phone numbers that are on that, do you recognize your own phone number?
No, I do not.
Okay. Going forward to the contents of that particular item, do you recognize the conversation about a sleep?
No, I do not. I know they had a sleep. I don't recognize this conversation.
Okay. With regards to the conversation about the snake, do you remember? What do you remember about the snake?
That they had a sleep.
What happened to it?
Objection. Relevance is sustained.
Aaron, may we approach that? Sure. And in that statement, where you asked, what is your daughter's phone number?
Objection. I don't remember.
If I were to show you the statement, would that help refresh your recollection as to whether or not you were asked that question?
I don't think you would, but you can show it to me.
You have permission to approach?
Yes,
Okay. 3 of 8.
If you could just read silently to yourself.
Okay. Looking at that, does that refresh your recollection as to what your daughter's phone number
I
was?
still don't recognize the number. It doesn't believe, I don't know if that's her number. I don't recognize the number.
Okay, so you don't recognize the
I
number.
got 3 daughters, so I don't know.
Understood on that one. So, the permission to treat the witness as possible.
Like they should have known she was gonna be like this, y'all. I wouldn't have brought her. If a motherfucker is not trying to testify, why bring them? All they're gonna do is hurt your case. That's all they're gonna do. Now, whatever she told them people previously, with this phone call with Melly and what she heard on the phone, I don't know if they could have found another way to use that evidence, but they probably better off without her. I don't know, but the defense probably they probably the motherfucker not allowed them to use it, said it was hearsay. So she probably had to come to court to testify, but I don't know. I don't know what other options they had, but this ain't it. This ain't it. The jury is sitting back wondering what the fuck is going on. I guarantee you. If I was on the jury, that's what I'd be wondering right now. Why'd they bring this woman in here? Straight up. Now the thing is, the jury is gonna get them papers that the prosecutor showing this lady. So they're gonna get a chance to read what she actually said. But they're still gonna have this visual of what she did in the courtroom as well. So I don't know how much weight it's gonna hold. Yo, what the fuck is he talking about?
Yes, the witness is on the stand, and for the state to suggest a witness who has already been sworn in the middle of testimony, and she goes and talks to her lawyer, it's kind of intimidation and
question be, who you want to talk to?
Yes, I'm talking.
All right, so we're going to be in recess. You talk to your lawyer, and you go ahead. You step outside, all right? And we're going to continue with the argument.
They going to hold 9 contempt, y'all. She gonna have to answer them questions a little bit better. I told y'all a couple minutes ago this shit was ready to get bad. And if she don't answer, they gonna hold her up in contempt. That's what the lawyer's gonna tell her. I guarantee when she come back, she gonna have a different tune. Guarantee you. Might not be 100% different because she's still trying to get Melly out of this situation. But she's gonna have to be a little bit more forthcoming than how she's been. Or she's going to be held in contempt and she's going to end up going to jail.
Allowed to speak to her attorney on that issue. And in terms of the prior statement on that, I still maintain that she has endorsed its authenticity and accuracy. Your Honor was provided with a copy of that deposition that the state referenced when we're talking about she indicated she was honest and truthful in that deposition, and she then endorsed the prior statement. So the prior statement should be allowed in on that, and if there's no concern as to any improper or anything
Yo, what it is?
because it will be instructed, as they always are, that
Hey, smoke.
statements by the attorneys are evidence.
What it do, bro? I ain't making no noise.
Yes, please. Your Honor, first of all, the state is now
Dissecting this motherfucking trial. Hey, man.
what we objected to and alerted the court to because we knew that this debacle was going to take place. I think it is evident that, yes, it appears as though the witness is not a major fan of the state. That's true. The state knew that going in.
I told y'all, yo. That's why I'm the best person covering this shit, man. I told y'all that from the beginning, man. They shouldn't have brought her. They shouldn't have brought her, yo. Yo, it serves really no purpose in forcing somebody to go to court when you know they don't want to go to court. Even if they might be vital to your case. But right now, she hurting them. She hurting them. They probably could have introduced those statements without her actually coming to court and backing them up. But it just would have been hearsay. You know what I mean? But I don't know. I guess you can weigh which was better. Even still, I think she hurting them.
These cases use the very language, surprise. In other words, what the state intended to do under a ruse, 803, 90.803 section 5 ruse, is put on the witness to impeach that witness for that sole purpose of impeaching the witness, to introduce an out-of-court statement that is inadmissible because the state understood that she recanted. The state, under the pretext, oh, we don't know that she's hostile. We just think her recollection is failing. And we believe under 90.803 subsection 5, we can just read her statement in. Unfortunately for the state, the Supreme Court has made it extremely clear that that witness has to vouch for the accuracy of the statement at the time it was made.
Okay.
And the Supreme Court also said in that
She have to vouch for the statement.
that in the context of an 803.5 exception, the contents of the record substitutes for the witness's testimony. This means that the reliability of the assertions rests upon the veracity of a witness who is present and testifying. The state is calling into question her veracity and calling her pretty much a liar, saying that she's feigning recollection and now attempting to essentially introduce a report of a police statement into evidence by the state testifying, asking the court to let the jury know that all this stuff that we're about to say, upon which we want to rest our case, is don't take it from me because I'm just a lawyer saying it. But then there's no point in saying it because there's no way to get it through this witness. She can't put her on to impeach, which is exactly what she's trying to do.
Mm-hmm.
The 8035 is a ruse, and that's not working out, and now she's doubling back to the original, which is let me call her hostile so that I can lead, and instead of listening to testimony from her, I'm going to read it out of this report.
I told y'all she was trying to lead.
So what happens is we're going to now be in a situation where she's asking the state to tell the jury, hey, what the lawyers say is not evidence. So it doesn't matter that this witness is going to say, I do not remember that number that you just read to me. That you just let me see. I told you I don't remember it. So I now the state wants to come back to the podium and blurt that number out. She just said she doesn't recall it. So what's the point of saying it other than to introduce it into the record through the state attorney's lips? So rules don't allow her to do what she's trying to do.
Thank you.
Senator, in further support of treating a witness as a hostile witness, this has previously been invited to defense, but this is the Instagram production for Miss Felicia Holmes that I'm showing the court now that she is previously identified as her specific Instagram, and that it is saying the promises that were made to us by YNW for me to quit my job and they would take care of us were all lies. They didn't want us talking with prosecutors, but now they have all disappeared. I quit my job based on what Track and his wife or company said. Now look, we can't go home. We're spending all my money I worked for and they taking trips and enjoying life. If you think I was a beast before, wait until this trial. I'm not holding anything back. I'm doing what I should have done in the beginning. They can call me Miss Snitch Bitch.
Whoa.
So Judge, it's very clear.
Whoa. God damn. Judge gonna let that go through too. Judge gonna let that go through. But that still doesn't speak to any guilt, to Melly being guilty. The promise that were made to us by Ynw Melly for me to quit my job and they would take care of us are all lies. Why the fuck would she believe Melly had the money to take care of them? That man ain't blow up till he went to prison. They didn't want us talking with prosecutors, but now they've all disappeared. I quit my job based on what Track and his wife. So if this is true, Track should be arrested for witness intimidation or bribing a witness. Company said, now look, we can't go home. We spend all our money I work for, and they taking trips and enjoying life. Damn.
From this record that my intention and what the witness has represented to me in all shapes and forms that she was going to be honest and truthful.
Oh,
so
this was an email.
Proper for calling her just for the purposes of impeachment is incorrect.
He has no one but his
On
mind.
that same Instagram production, and this is in June of 2022, Felicia Holmes is saying they made me quit, told me that they would take care of us until trial was over. But guess what? Lies as usual. I was making $9,000 weekly. I didn't need shit from them.
Why the fuck would you quit your job making $9,000 weekly?
I got something for Track though. He lied to me and my child for the last time. Again, saying you're going to air him out to the prosecutor. So Judge, in terms of the defense of the representation and counterfeit is just being called for impeachment. It's also clear that this witness has received multiple.
The fuck was she quit? If she's really making $9,000 a week, why the fuck she quit her job? She's making great money. Let's fuck around down there $200,000 a year or something close. That was stupid. If she did that shit, that was on her. I'd have never done shit like that.
From the defendant, based on her own statements there, But she has endorsed that that was her Instagram on that.
So, Council, there's a couple things.
So the Instagram message.
Number one is you indicated that there was the testimony was going to be admitted because it was unless it's forget the statute number.
9803 it's a past recollection reported.
Past recollection recorded, and you
Correct.
gave me the polite case.
Yes.
And that indicates that you have to have a proper foundation, but it has to be not only there's a proper foundation, but it has to, the hearsay statement was inadmissible in that case because the witness did not vouch for its accuracy or correctness, which is what we have here. The witness isn't vouching for the correctness or accuracy of the statement. So it doesn't meet.
So it was hearsay anyway.
On the other issue about impeachment, this is not what she said. She said gave me a different answer. What I tried to read before was something from a couple of cases. And again, the synopsis of at the end of it. This is I'm just reading again from the SL child case, the state 993 Southern 2nd 1108. It just says the Florida rules of evidence provide that prior inconsistent statements are admissible as substantive evidence if the declarant testifies at the trial or hearing subject to cross-examination regarding the statement, and the statement is inconsistent with the declarant's testimony given under oath, subject to the penalty of perjury at trial, at a trial, hearing, or other.
Get ready, like, hey, what's up, y'all?
Goes on and says, interpreting this position, the Supreme Court of Florida recognized that a statement given during a police investigation is not a statement given at and other proceeding. So, then if you agree, I don't know where we're going with this, Council, respectfully. It seems to me under either scenario, that statement doesn't connect. Now, I do have a message from Mr. Bears, B-E-R-E-S. He says he's Ms. Holmes' attorney. He would like to speak to me. I don't know what he wants to talk with me about. He can't really, I'm assuming it's his testimony. But anything he can say right here in open court, I don't have an issue with that.
That's fine, Your Honor. I really question the purpose in advising my client, Ms. Holmes, to consult me for a lawyer. I take it as an implicit threat to Ms. Holmes. We have an agreement that she comes in here today.
Yo, this is why I'm gonna keep saying this shit to people get understand. This is why, yo, when you're involved in stuff like this, you do not get other people involved. Yo, you do not get. He should have never called this girl if that's what he did. Yo, you don't get other people involved in this type shit, yo. Because now look what's going on. Now this woman's life is basically her life is in jeopardy. She fuck around and go to jail if she don't comply to what the state is saying she said in the beginning. And Melly's life is on the line. if she do comply. So it's like now she's stuck between a rock and a hard place where she ain't have nothing to do with this shit. All because Melly decided to get his girlfriend involved who he probably ain't even dealing with no more. And man, just 5 years down the line, I'm pretty sure she moved on. And you heard the mother, how she feel about the whole situation with Track and they ain't taking care of him like they said they was going to do. But this is the reason, y'all. This shit fucked up for real. That lady's in a fucked up situation, man.
You testified. She's done that. She's honored her agreement. And, she's answered all the questions put to her. She may not be answering the questions to the satisfaction of the state, but she has fulfilled her agreement. And now Ms. Holmes is again placed in fear. And that's all I have to say.
Thank you. All right, let's, anybody need a rush for breaker? You ready to go?
Yes, sir.
Are you, Judge?
I think someone on the
I need to.
Sure. We'll take a short recess.
Yeah, y'all. Melly put this girl in a fucked up ass situation, man. Fucked up ass situation. Cause she's gonna have to say I knew they wasn't gonna continue to allow her to keep going on like that. Ain't no way. She wasn't giving them nothing. She wasn't answering no questions. And I'm sure Melly and them probably offered some kind of bread or shit. They could have threatened her. Ain't no telling what the fuck they did. But now she's stuck between her freedom and saying what the fuck Melly and them told her to say. That's a tight spot, man. For a civilian. You know what I mean? You don't put people in them type situations, man. You don't put people in them type situations, man. But I get it. Melly and them, they was young as shit. Fuck, man, was 19 years old. He was a fucking kid. Her daughter was a kid. That's why she even got involved. But this can be a learning experience for other people moving forward. You don't do that shit to people, man. That lady's scared to death. Lady probably never been no fucking trouble. She said she had a pretty good job. Now she fuck around and go to jail. If she'll say what the fuck the state told her to say. Shit, man, you can get a couple months for that shit, man, for perjury. And that might not sound like a lot of time, like to somebody that been in prison, but for a civilian, shit, man, that's fucking life changing, man. I told y'all. Anytime I got questioned by them motherfuckers, y'all. Anytime I got questioned by them people, I didn't bring nobody. And I was young too, like Melly. 19, 18, 20. I mean, like, you don't bring other people into them type of troubles, man. You don't. Because if she was to tell on him, would she be wrong? I don't think she would be. She wouldn't be wrong at all. Because for one, she a civilian. For two, she ain't had nothing to do with that shit. She doing what the fuck civilians supposed to do. They got this. They put this woman in a position to be a fucking street nigga. That's dirty. All she was trying to do is protect her daughter at the end of the day. My bad, keep leaving you. I'm hungry as shit, but that's why I don't go live. I be doing too much moving around to really sit down and go live for hours. Like, I'm fucking got 2 kids upstairs and shit. It's like, yeah, man, like, I don't know how these other people be living, but I'm an active father, man. Like, a full-time one. I can't really be going live for hours and shit. And not stay stationary. I mean, I can do it, but I can't stay stationary. Cause just be there, you know what I mean? Damn, I feel bad for that lady though, for real, y'all. That's fucked up. She got the state threatening them. She got the defense team, Melly and them probably threatening her or got some type of deal over her head. Like she in a fucking tug of war right now. And at the end of the day, she the only one gonna pay. Regardless of which way she go. Maybe I don't know what the fuck going on. See, y'all, when I was in the situation, y'all, I was reading up on my case. I wanted to make sure if I was in this type of situation, whereas I was in a trial situation, I wanted to know the lingo. I wanted to know everything. Like, I want to make sure these people don't throw me, man. Like I told y'all, cause them lawyers will do that shit to you, man. You gotta make sure, at the end of the day, you gotta look out for you. Yeah, you pay them, yo, but sometimes they got outside entities that influence their decision making. So you gotta be fully aware of what's going on. Now, if it's just a little bullshit case, well, you talking about it, you mean, I guess they're mad, but you talking about a case where your life is on the line and you could possibly go to prison for 20 plus years, man, fuck that. You better read up on your case.
The court to order this witness off the stand. I think the state has demonstrated that the only purpose for which they don't have this there is for the improper purpose, and they're compounding the prejudice by having her remain there.
The judge ain't gonna agree to that.
The state has something that's admissible that they can prop to this court. That witness testimony needs to be concluded.
Thank you. They were here.
Judge, proceed now. There's additional information and things that's open to talk about.
Yeah, the judge ain't gonna agree to that.
Thank you. So this is my thought, counsel. I don't have a problem declaring the witness to be hostile to the state and allowing you to ask leading questions. I'm okay with that. I think that's been established. She's wearing an ankle monitor that was put on there by the state. I guess pursuant to this.
That she got an ankle monitor on? So they made her, they made her, what's that, fuck that shit called? Retainer?
The problem I don't want to have.
They put a detainer on.
So clear is I don't want you to regurgitate things that are in her statement that she's not.
Retainer.
Doesn't comply with either of the two rules we've been going over. So I don't want you to be saying, well, did you say to, the police officer, Mr. Moretti, or whatever, the officer's name is Detective Moretti.
The jury must not be in the room.
You saw them on FaceTime or whatever it was that they were on that date when the incident in question happened, and Mr. Demons told you X, Y, and Z. All right? The witness hasn't subscribed that the statement was accurate, so it's not getting in under reported recollection, and it's not getting in as impeachment because it's a police investigation, not a deposition testimony or something along those lines. So it doesn't get in the way I read the rule under either of those two sections. So I don't want you getting in the back door, which you can't get in the front door.
No, just so I can make it clear, is Your Honor holding or stating that a police report cannot be used to impeach someone?
No,
Or,
I
okay.
say that. What I said was the statement's in the police report, right? You can't just have that, read that back to her. Didn't you say this to the police officer? I don't want that being done. I don't think that's appropriate. She says she doesn't remember the statement, doesn't know it's accurate. She didn't rely on its accuracy.
Understood. And I just want to make sure it's also clear, under 9803 sub 5, the past recollections reported, there's no requirement in any of the case law or statute that the statement be sworn on that. If you look at that, because if there's other statements this witness has made that she may endorse as being truthful and accurate, and I'll have to ask her on that, then those are possibility of other ones that could be put in.
officer on the day in question. What's the date that statement was made?
December 12th, 2018.
Nothing from that statement should be.
She'll ask you whatever questions she needs. Appropriate, you make your objections, but I don't think it's appropriate to be asking, didn't you say this, X, Y, and Z. I don't think that's appropriate, because she's not subscribing that this is what she, I think that statement was truthful, so I don't want you to just be regurgitating the statement, and asking her that. I don't want that done, and I don't want you to do, anyway, that, we'll see where it goes.
Yeah, just one thing, Your Honor, I'm sorry to belabor the point, but I want to make sure that the state doesn't confuse the court's ruling to be on a form over substance, and instead of saying, didn't you say this, say, isn't it true that, or anything where the contents of that report are uttered out of her mouth that she knows this witness had not adopted, and she's going to get a no, and she's just putting it into the record. It's improper. And
I made myself clear, but that's why she's going to be able to, counsel's going to be able to ask whatever questions she deems appropriate. You make the appropriate objection if you think it's objectionable. I'm just going to rule and go forward like that. I don't know what you intend to ask counsel. I just don't want the contents of that statement, regurgitating that in some form of leading questions. All right. I'll ring the jury. Let's get the witness back.
Time to elevate your game. At Tennis Point, we've got you covered. With the latest and greatest gear in the market, it's a one-stop shop. Visit tennis-point.com today.
Thank you. Entering. Please be seated. Let everyone see reflect the votes for a jury. This matter to the zone.
Okay, so we left off, we were talking about a pet snake.
Yes,
Do you remember there being a pet snake?
I remember you talking to me about it yesterday.
Okay. And with regards to that snake, you recall it unfortunately passed away.
I'm pretty sure, probably, I'm not sure, it's not here, I'm pretty sure.
Do you remember the name of that pet snake?
No,
In terms of the owners of that snake, do you remember who owned it?
I just know it was, I know the owner was, it was in the house with Mariah.
Okay. Where in Mariah lived that snake?
Should it be a Mark?
And do you know the address?
No, I don't.
Who did she live with?
She was my boyfriend, but you know.
Okay. Are you telling the ladies and gentlemen of this jury that you don't remember your phone number and
I'm telling you guys, I do not remember my phone number. I don't remember.
And are you telling the ladies and gentlemen of this jury that you don't remember your daughter's phone number?
No, I do not remember my daughter's phone number.
And there's nothing that would refresh your memory or recollection whatsoever?
Ask and answer.
That was 4 years ago. I've had so much trauma in my life since then.
Of course. So, is it fair to say that you were worried about Melly when you came down here to Fort Lauderdale on October 26, 2018?
Was I worried about him? Yes, I was.
You were worried about him because he had just been involved in a drug fight?
No, because they said his friends had been in a drug fight.
And you were worried about him because he was hiding in some bushes.
I don't remember his bushes.
What do you remember?
I sustain the objection.
What do you remember?
I just remember him saying for us to come get him.
When you made contact with him later that same day at Frito's house,
Yeah.
is it fair to say he had no blood on him?
No, he didn't have any blood.
And is it fair to say that he left Frito's house and went up to a video shoot that afternoon evening?
Yes, he did.
Did you go to that video shoot?
No, I didn't.
Did Mariah live with Mr. Dennis after the homicide for a period of time?
Yes, she did.
Did you live in a condo in Miami with him?
Yes, she did.
Okay. Have you made other statements about the events of October 26th of 2018?
I don't remember making any other statements.
Do you recall an Instagram conversation with the co-defendant Courtland Henry?
I don't remember it.
I'm finding a approach. See if this refreshes your recollection as to that conversation. It's 3 pages.
Except for Mark Council.
Not yet, Your Honor.
I don't remember it. I don't remember it.
You don't have any recollection of that?
I don't remember it.
Is that your Instagram?
Hold up, y'all. Hold up. I missed it.
Yes, it is.
Okay, and the conversation.
Let me go back.
And October.
Jury answering.
No, done.
Ladies and gentlemen, thank you. Please be seated. Let everyone see your reflect the votes for a jury. This is matter for the gentleman. City Council. Jury, and this all reasons why we understand. Apologize for the delay. Council ready to proceed. Please.
Okay, Ms. Holmes, we left off, we were talking about a pet snake.
Yes.
Do you remember there being a pet snake?
I remember you talking to me about it yesterday.
Okay. And with regards to that snake, you recall it unfortunately passed away.
I'm pretty sure probably, I'm not sure it's not here, I'm pretty sure.
Okay. Do you remember the name of that pet snake?
No, I don't.
And do terms of the owners of that snake, do you remember who owned it?
I just know it was, I know the owner was, it was in the house with Mariah.
Okay, where did Mariah live at that time?
She lived in BMR.
And do you know the address?
No, I don't.
Who did she live with?
She lived with a boyfriend, but you know.
Okay.
What the fuck did this snake got to do with anything?
Are you telling the ladies and gentlemen of this jury that you don't remember your phone number in
I'm
October
telling you guys,
2018?
I do not remember my phone number. I don't remember.
And are you telling the ladies and gentlemen of this jury that you don't remember your daughter's phone number?
No, I do not remember my daughter's phone number.
And there's nothing that would refresh your memory or recollection whatsoever?
Judge, ask and answer.
That was 4 years ago. I've had so much trauma in my life since then.
Of course. So,
I said, of course.
is it fair to say that you were worried about Melly when you came down here to Fort Lauderdale on October 26, 2018?
Was I worried about him? Yes, I was.
You were worried about him because he had just been involved in a drug fight?
No, because they said his friends had been in a drug fight.
Okay. And you were worried about him
Way to answer that.
because he was hiding in some bushes.
I don't remember his bushes.
What do you remember?
I sustain the objection.
What do you remember?
I just remember him saying for us to come get him.
When you made contact with him later that same day at Freedom's house,
Yeah.
is it fair to say he had no blood on him?
No, he didn't have any blood.
And is it fair to say that he left Freedom's house and went up to a video shoot that evening?
Yes, he did.
Did you go to that video shoot?
No, I didn't.
Did Mariah live with Mr. Dennis after the homicide for a period of time?
Yes, she did.
Did you live in a condo in Miami with him?
Yes, she did.
Okay. Have you made other statements about the events of October 26th of 2018?
I don't remember making any other statements.
Do you recall an Instagram conversation with the co-defendant Courtland Henry?
I don't remember it.
Okay, if I may approach, I'll see if this refreshes your recollection as to that conversation. It's 3 pages.
Except more counsel.
Not yet, right.
So who's the message between her and Portland?
I don't remember.
You don't have any recollection of that?
I don't remember.
Is that your Instagram, LaneQueen258?
Yes, it is.
Okay, and the conversation that you don't recall on that whatsoever?
Yeah, I don't remember it.
Okay. Is your testimony here today that you lied in those statements?
That I lied in my statements.
The allegations that you made to Mr. Henry?
I don't remember making those allegations, so I don't.
Do you remember sending screenshots of those allegations to a detective?
I remember sending a detective something stating that I didn't directly Portland.
No.
Because I remember that.
You remember sending screenshots of conversations?
I remember telling him that I did, because he reached out to me and asked me that I directly killed Portland. And I said, no, I did not directly Portland. I remember that.
Was there any threats made to you by the defendant?
No.
In terms of your daughter, Mariah, where is she?
I don't know.
After this incident, did she live with the family of the defendant?
She's always lived down there. Before this incident, she always lived there.
And your testimony to the ladies and gentlemen of the jury here today that you saw Janelle Dean on October 26, 2018.
I think I saw him.
That you spoke with him and heard him on the FaceTime conversation.
I did speak in this.
And it's your testimony that he indicated that it was some sort of shooting that occurred.
Yes, I did, yes.
Okay, and it's your testimony that you saw him on that, your daughter's cell phone, as a video call.
I saw it.
Is it your testimony today that after that you called Jane King?
Yes, I did call Jane.
And in terms of the conversation with Jane King, that occurred immediately after the FaceTime?
Not probably immediately, but sometime after. I'm not quite sure the time. I don't remember the time it was.
And it's your testimony to the gentlemen of the jury today that you were dishonest in your first statement?
I don't remember my first statement.
Okay. Is it your testimony to the gentlemen of the jury that you were
I
lying?
don't remember my first statement. I have no reason to lie to you.
Yes or no? Did you lie to police?
I did not lie to you. No.
Yes or no? Did you lie to police?
I didn't lie to you. I don't remember my first statement. If you're trying to make me say I remember my first statement, I did. For me to say no, I didn't lie would mean I remember my first statement. I don't remember it, so I don't remember.
Well, if you need more time to look it over, I have a copy of the
I looked it over and I still don't remember it.
Well,
I did it over 100 times. I don't remember.
well, if you'd be so kind as to do it one more time.
Yeah, sure. I'll do
You
it.
can say that to this jury that this is not truthful.
Yes. Please.
Objection asked and answered 5 times.
Thank you, Commissioner Miller.
All these objections that's getting overruled is for appeal purposes. Normally with an objection,
I honestly do not remember any of this on here. I don't remember.
if it gets sustained, then I'm allowed to answer the question.
Is it your practice to lie to law enforcement?
Objection.
Excuse me, can I
I'm
see
sorry
the
for the line.
Quiet, please.
So you hear him say objection is noted. That's just so it's in court it's documented in the court system.
You're saying is that
Stay.
I don't know.
Excuse me, I should stay in objection.
Okay, so going back to the relationship with your daughter and the defendant.
Yes.
How long did that last?
3 years. I'm not quite sure how.
Okay. During the course of that relationship, did she have multiple photographs of him?
I'm pretty sure she did.
Videos?
I'm pretty sure she did.
After this incident, on October 26, 2018, at Frida's house, is it your testimony that your daughter went upstairs with Mr. Dennis?
She did. They did go upstairs.
They went upstairs. And do you know about what time you got to Bremerton?
I probably got to Broward. Maybe. I can't really remember the time. Maybe. I don't know. But 1 o'clock was after lunch. Because we went to right after. So it was after lunchtime. It was 1 o'clock.
Do you remember going to lunch?
Yes.
Do you remember where you went to lunch?
I don't remember which restaurant.
Do you remember who you went?
My daughter and AA.
And that's James Francois' wife?
Yes.
And do you remember, your testimony was that you remember the defendant, how he was dressed without on his clothing?
I don't remember exactly what he had on, but I just remember there was no blood because I would have freaked me out. So I know they had any blood on.
No blood on him? Is it your testimony to this jury in terms of that you went to Frito Bay or Frederick Gibbons' house?
Yes.
Is it your testimony to the jury that there were other individuals present at that house? Who was it? Do you recognize any of the individuals?
No, I don't.
Okay. Your daughter, she was present?
Yes.
And in terms of your appearance here today, you don't want to be here.
Yeah, you made it on here.
I did.
Okay,
So a subpoena
Never
prior?
served, never served.
And so you were ordered by the court to show up.
You never served me originally. That was a lie.
And in terms of your job,
Yes.
did you quit your job?
I got fired because you put me in jail.
And prior to
Damn, she got locked up.
Yes.
before you were put in jail, did you quit your job?
No.
Okay. So you never quit your job.
I had to leave because you told my lawyer to put a warrant out for me. So I had to leave my job.
Okay. So you left your job.
Yes.
Did the defendant ever offer to pay for you and your daughter?
No, I make my own money.
Have you ever made sense contrary to that?
I don't remember.
Second answer, Attorney?
Counter objection. Ms. Schultz will
Sure.
Can we approach? Sure. Are you done with that?
I told y'all, every time you get the camera on him, they tell him to do something crazy. The fuck is he doing? What, he got headphones in?
Okay. Ms. Holmes, were you ever told the defense, or the defendant rather, would take care of you and pay for your bills? Have you ever made a statement that is different than that?
I've never seen anything like that.
Can I approach her?
Sure.
Okay. So, Ms. Holmes, is it your statement testimony that you never stated the promises that were made to us by YNW for me to quit my job and they would take care of us were all lies? They didn't want us talking with prosecutors, but now they've all disappeared. You never said that before.
I don't remember saying anything.
Objection, Your Honor. Move, Mr.
Thank you. Watch your sidewalk.
Or he could just be wrong with Shorty, man.
Ms. Holmes, did you ever say the defendant made you quit your job?
I never seen anything. I don't ever made me quit my job.
Objection.
If I may approach you? I'm not sure who's next. So, Ms. Holmes, I'll ask you again. Have you ever made a statement that the defendant made you quit your job, that they would take care of us until the trial was over?
I never say anything like that.
So you're denying making that statement?
I never say anything like that.
Oh.
Objection. Your Honor, can I just have a standing objection so we don't keep interrupting?
Make any statements you heard on the standing objection.
So under defense,
That's fine. Go ahead.
okay. So, Ms. Holmes, in terms of
The fuck?
permitted statement to the effect, you were told to quit your job and the defense would take care of us.
Of the judge.
Excuse me.
The defense.
You have another motion. What's the objection?
Calls for hearsay. It's immaterial.
Not what the estate said, that you say something about the case. It's overruled. Not what was said. Excuse me. Not what was said. Was there a conversation?
Was there a conversation that your daughter told you were having in this case? With Julie? Did your daughter ever?
She never told me. She hasn't. I asked my daughter, did she know anything about this case, and she said no.
Have you ever made a statement different than that?
Not that I can recall. No, I don't remember saying anything like that.
Manufacturer?
Yes, ma'am.
We object.
You want to show the counsel first? Can we approach? Yes. So.
ready to take a nap, y'all. Getting tired. They keep pausing the proceedings and shit. I'm intrigued to see how this play out, though, to be honest. I think they're going to try to end up holding her in contempt. But she answering the question, she's just not answering in the way that the state wanted her to answer them.
Object to lack of foundation, calls for hearsay, speculation, unless they can establish that that witness was present.
Thank you. Objection noted. That's what I previously ruled on sidebar. Proceed. To your approach.
Showing you your messages from Instagram from February 5th, 2021.
Was that Instagram? Is that the one Instagram stands for Portland?
Ma'am,
I
sorry.
don't remember that Instagram.
Look at it.
I already looked at it. You already showed it to me.
So is the
I don't remember that. You showed it to me like 3 times already.
so you don't recall making
I don't
a
recall
statement
making a
from
statement. No.
One at a time, please. Let her finish her answer before you ask the next question.
So you don't recall making that statement?
No, I don't.
So you don't recall saying
Objection. Sustained.
so, Ms. Holmes, in terms you said that your daughter didn't tell you.
Objection, asked and answered.
Sustained.
So did you ever make a statement different than that?
Objection, asked and answered.
Sustained.
Into the statements that with regards to October 26th of 2018. Is it your testimony to the jury that you remember coming to Fort Lauderdale.
Objection, ask and answer.
Sustained. Listen, I just want one of you making objections. Whoever's going to handle them.
Yes, sir.
All right.
I apologize.
Ms. Holmes, is it your testimony you don't remember why you came down?
I told you why I came down.
Okay, why is that?
Objection, ask and answer.
Sustained.
Ms. Holmes, have you ever,
She don't not ask the question different. See, she not good.
let me rephrase.
You can ask the question, you just gotta know how to ask it.
Ms. Holmes, did your daughter ever threaten to cooperate with law enforcement?
Objection.
Sustained.
Ms. Holmes, did you threaten to cooperate with law enforcement?
Objection, ask and answer.
Different question.
Why don't you come sidewalk? I want to see the question, please.
You gotta help her figure out a way to ask the motherfucker. Yo, a good state's attorney? Man, I done seen some good state's attorneys, man. She ain't that. I'm talking about that shit would have came out like rapid fire. As soon as he objected it came back with another one. The same question, just a different way. Like the people that know who was some real good state's attorneys. Were they state's attorneys? No, they was defense attorneys. What was a good ass state's attorney, man? That we probably all that was noted. That was the trial that most people seen. I can't even think of it right now.
Make any statements about what happened on October 26th of 2018?
Objection, ask and answer.
I don't know what statement you're talking about. Rephrase your question. Be specific.
Ms. Holmes, did you ever make any statements specific to what was happening in the car on October 26th of 2018 prior to the homicide?
Objection.
Thank you. I still come on sidewalk, please.
She can't. She don't know how to ask the question. She need to ask her, were there any statements made? That's not answering the question. And then after she probably say no or yeah. Then she'll ask, do you remember what you said?
So, Ms.
She all she gonna do is say no though.
Were you present when your daughter spoke to law enforcement?
She was there.
Do you recall about when that happened?
She was 17 at that time.
Without naming what she said on that. Do you remember where that statement was taken?
See? Like how the fuck do I know that and she ain't know that?
When you came down to Fort Lauderdale, was your daughter concerned for Mr. Dennis?
Objection. Calls for a conclusion on part of this witness.
Based on your daughter's demeanor, how was that changed?
Sustained.
Man, this defense tear that prosecution team up, man. They need help. They get another player. They better tap somebody in.
Objection.
Tag somebody in like wrestling.
I'm sorry, repeat the question?
When you arrived in Fort Lauderdale, did you ask Mr. Dennis what had happened?
No, I did not.
Nothing further.
I have one question.
Yes, sir.
You came here and one of your first...
What I tell y'all, look how
Objection, Your Honor, improper.
look how the defense is not even questioning their witnesses, y'all. They don't have no faith in the state's case at all. They don't even feel like they have to double back and question the state's witnesses because the state is doing such a horrible job presenting their case.
I haven't asked you.
Counsel, you directed your comments.
I'm sorry, I haven't asked anything yet.
Ask your question.
When you first took the stand, you said, I feel threatened.
Yes, sir, I do.
Who do you feel threatened by?
Objection, Your Honor.
Overruled.
Christine Brandon, the prosecutor's office.
This prosecutor.
Yes, I do.
Thank you.
Anything else in this witness?
Yes, sir. Ms. Holmes, you said you feel threatened by
Of
me.
course.
Okay. Did you fail to appear for numerous court appearances?
No, I never served me, lied.
Okay.
Lied to the court.
And with regards to, did you work in Redding, California?
Yes, I did.
Okay.
Material.
Overruled.
And so that was a location you were at?
That's where I was traveling nurse at. Yes.
Okay. And in terms of
She was a traveling nurse.
prosecution, you have been served on various occasions.
They do get paid good money.
You served me a subpoena on November to be the next 15 hours in California, 10 hours away. It wasn't even served correctly.
And prior to that, you were served with a subpoena in
Never.
February of 2019.
Never served me. I know you served to a location. I didn't live at it anymore.
Do you recall coming to the courthouse in February of 2019?
Objection beyond the scope.
Excuse me.
Anything about the courthouse?
Excuse me. Come sidebar.
Yeah, this prosecution saying this case too big for them, man. Melly lucked up if he did do this shit, doing this shit in a small town. I'm sure that wasn't his thinking. Niggas ain't smart like that. But it's definitely working in his favor.
Video. But what if no one watches it?
In terms of your feelings and ill will towards the state and myself,
I just feel like a lot of innocent people.
and does that influence your testimony today?
It's not influencing my testimony.
Have
No,
you-
I'm telling you.
Have you- that's not-
I
you're not-
Excuse me. Hold on. Only one of you can talk at a time. You ask the question, counsel, you answer it, and when you let her finish her question, and then when she starts answering the question, you let the witness answer her question, all right?
Yes, sir. So my objection was non-responsive on that one.
Ask your question.
So, Ms. Holmes, in terms of the court order that was issued, you're aware that that was found to be valid?
No, I'm not aware of that at all.
Okay. You hired an attorney to go and represent you with the 4th District Court of Appeals?
He had to hire an attorney because he tried to get him as far as.
And
Damn.
full statement.
Objection. Excuse me. Counsel, you're not testifying.
I
all right?
agree with that.
Excuse me. You ask a question, all right? That's it. You ask the question.
And so, with regards to that, you hired an attorney?
Yes.
And you then tried to get any sort of court order requiring you to be here in court thrown out?
No, what I did was I hired an attorney because you were saying you served me a subpoena that you never served.
And that was found to be valid?
You never served me a subpoena that was never served me.
No.
I've never seen a subpoena from you with those addresses that you said you served. Those are not my addresses.
Your testimony said you have never been served to appear in court.
Objection. Sustained. Excuse me. Sustained.
And so, with regards to your feeling threatened on that, have I ever, any sort of physical violence against you? Okay. Do you have any written threats from me?
It's intimidating. You've intimidated me this whole time.
And,
Yes, now.
and in terms of your participation in this case,
Yes.
you understand that you were served a subpoena to appear here today?
You served a subpoena after you arrested me.
And
You served a subpoena at the jail. I
and
was
you
around council.
and you understand you were here pursuant to that court order?
I'm you.
And that requires, under the law, to comply with court orders to and that compel attendance of witnesses.
I
sir. Thank you. This witness excused?
Yes, Your Honor.
Thank you, ma'am. You may step down. You're excused. Want to think back on her, please?
Hey, that was crazy right there, man. That was wild.
Today. So my thought is, remember the admonition. We'll see you back on Monday, though, 9 o'clock. Remember, do not discuss the case. Tuesday. That's right. Monday's a holiday. Thank you. Tuesday. Don't discuss the case. Don't form any opinion about the case. Don't lie.
They ended early today.
No research. All right. Same admonition you every time we break.
They normally go to about 4:30.
You to follow. All right. Just leave your head on your chair. We'll see you back on Tuesday, 9 a.m. Thank you.
What the fuck? Today Friday? Today Thursday. Yo, they should have never forced that lady to testify, man. I think that was a bad move. I think that was a bad move. I don't know how the jury going to view that whole confrontation, but the state ain't really get no information. They ain't get what they was trying to get out of it. Only thing they showed was that the lady gave statements that she's not standing on previously. That's all they showed. They ain't showed nothing more, nothing less. But like I said, the jury is going to be able to get them, they're going to have them transcripts and the messages to be able to read over when they deliberating on the case. But we'll see how that shit play out, man. I'm tired as a motherfucker, y'all. I keep staying up all late and shit. Yeah, but I got some more videos coming out later, y'all. I've been working on this video for a couple of days now. Other videos coming up in between time. In the main time, between time, I've been doing them, but I got this video I've been trying to get out for a couple of days, so look out for that. You know what I mean? I'm staying on top of that Boosie shit. You know, ain't no more news come out about him yet. Trying to figure out what the fuck he locked up for. I tried to look him up. He ain't in the system. Or at least they ain't showing him in the system. That's how that shit play out. Well, shit, man. Thank y'all for rocking with me, man. Subscribe to the channel if you're on Twitter. Keep it G News. I'm out.